Today, we are here for the pretrial for the State of Georgia vs. Cain Nightshade. How do the defense plea?
Your Honor, can we have a reading of the charges?
Armed robbery and aggravated assault.
Say not guilty now.
I am innocent. Not guilty.
Thank you. Next time, not so loud, please, sir. We are going to start off with the prosecution first.
Yes, Your Honor. For bail we are asking for a $10,000 due to the severity of the incident in question as well as with the possibility of Mr. Nightshade being a danger to the community.
Your Honor, we seek a reasonable bail far less than that. In no way, shape, or form has the prosecution offered any evidence that my client is a danger to the community.
Objection, Your Honor. We are not here to prove guilt or innocence.
Your Honor, the DA has stated that my client is a danger to the community. He should be required to provide evidence to that.
Your Honor, he has been accused of aggravated assault, which in Georgia law requires some form of deadly intimidation. The law is proof enough.
Your Honor, the purpose of this hearing is to determine if there is enough evidence to go to trial. In addition, the prosecution can add 10,000 charges. They are all words, but still, we haven't heard any actual substance. Again, I ask for the court to impose a reasonable bail, if not roar.
Prosecution is absolutely right on his part, ma'am.
Your Honor, the defense is pulling at straws. While it may not be just words, as the case file does show his charges, the file has been made available to the defense. Whether or not they looked at it, the prosecution cannot help, and can merely suggest Mr. Nightshade maybe look into a more prepared lawyer. We also would like to remind the defense that we are only recommending the bail, but it is also immediately up to you, Your Honor, not us.
Your Honor, if I may remind the prosecution, the defense can make a recommendation also.
And what is your recommendation?
Your Honor, I ask for something reasonable. Mr. Nightshade isn't a member of the local country club or well off. Cash bail is a sentence for him. I leave it up to you to decide what is reasonable.
Your Honor, while I understand where the defense is coming from, may I offer the old saying, don't do the crime if you can't do the time.
I object. I didn't.
Your Honor, there is no presumption of guilt here. This isn't Russia. I ask that the district attorney's comments be stricken from the record. Shush.
Mr. Nightshade, is there an issue controlling your outbursts?
Your Honor, could we get back on track here, please? The defense is attempting to grandstand to deflect from Your Honor's ruling of bail. May we continue, please?
Your Honor, the DA's comment about don't do the crime is a presumption of guilt.
Again, grandstanding and deflecting from what we are here for, Your Honor.
I didn't make the comment, sir. You did to the court.
Your Honor, while she refrains from addressing the court, can we continue without this foolishness?
Your Honor, I don't understand the DA's commentary. I asked for reasonable bail, yet he continues to run an ongoing commentary on how he believes the court should be run. May I suggest he should run for judge?
Your Honor, my personality isn't on trial here. May we continue, please?
Your Honor, the defense asks you to set a reasonable bail appropriate for Mr. Nightshade's financial circumstances. And again, cash bail only affect poor defendants, not well-off ones.
I have already made up my decision on this matter. Judgment is bail set at $10,000. However, he is required to make 10% of the payment. If he makes bail, he will be required to wear an ankle monitor.
Your Honor would like to remind the defense that his suspected crime are felonies, and a higher bail recommendation is to be expected. Thank you, Your Honor.
Your Honor, may I suggest a lower cash bail along with electronic monitoring?
Your Honor, you have spoken on this subject already. It should not be under questions any further. That's disrespectful to you, Your Honor.
Ms. Angel, I am allowing 10% of payment. Now I can change it to full payment.
Again, Your Honor, the district attorney is trying to tell the court how to run their court. That is quite reasonable, Your Honor. Thank you.
I would like to see both of you in my chambers.
Yes, Your Honor.
Your Honor, I do have a motion to bring up to you first, if I may.
You may, and make it quick.
Your Honor, per the report sent over from the sheriff's office, a Mr. Reyes was the one who informed the sheriff's office of the alleged crime. I find it interesting that said Mr. Reyes is now employed by the sheriff's office after this report. I would like to make a motion that any testimony and/or evidence that was derived from this Mr. Reyes be stricken and removed from the record.
Objection, Your Honor. Mr. Reyes' employment isn't part of these matters. nor should they be, as this is a separate incident.
Your Honor, there is a dark whiff of dirt upon this. Mr. Reyes gives the report. Mr. Reyes is hired.
Your Honor, I still object to this matter, as Mr. Reyes' employment is not on trial here, nor should it be.
Your Honor, I leave it to you to consider my motion.
Judgment is $10,000 with a 10% payment and electronic monitoring. Again, both of you in my chambers.